Good evening. I am reading the first part of this Verba Juris Bar Review Notes, Volume 1. So, Volume 1, the Book 1, composed of political and international law, labor law and social legislation, civil law, taxation. Continuing. So, first Sunday, political law, labor law. Second Sunday, civil law, taxation. So, we usually start with the desired answer, then proceed to support said conclusion with principles of law, establish jurisprudence, and even with some quotes that seal the deal. For some, they would first adopt an illustrative case, then build their answer towards the desired conclusion. To this I say, to each his own. Yet, while we would advocate for the development of one's own personalized manner and style of communication, we need to take into consideration for purposes of taking the bar examinations several guides or suggestions in order to allow you to craft your answers correctly, simply and close, concisely. First off, before you lift your pen to write your answers, read and reread the question until you fully understand what it wants. Remember your training in law school, always be responsive to the question posed. In order to be responsive, you need to conceal yourself first with issue. In order to be responsive, you need to concern yourself first with the issue that the question wants you to resolve. So there, responsiveness is your first consideration. Now that you know what the question wants you to answer, you now assemble the materials that would assist you in resolving the issue first in your head. Play with the theories that first come into your mind. Remember, you have been reviewing for most part of the year, and usually your mind automatically presents a tentative answer to the question. That is how our mind works. Owing to the daily grind we had during law school for 4 years and more, and once you decide on a resolution, you begin to bring to mind the supporting concepts and principles of law, jurisprudence, if any, to enable you to establish your answer convincingly. The Verba Juris contains doctrinal statements or pronouncements by the High Court that can assist you in citing jurisprudential support to your answers. Now that you have a working solution, you now put pen to paper. Remember, don't make the mistake of simply downloading every bit of information you remember as your answer. The examiner is not looking for an information dump on your test booklet. What the examiner is looking for is how you proceed to tackle the question, and more importantly, how you manage to draw out the clause draw out the law and jurisprudence in a coherent whole in resolving the issue. In order to do this, you need to write in a logical and organized manner, clearly showing to the examiner that you understood the issue being raised and found the applicable law and appropriate jurisprudence to resolve the issue. For me, this is the true test of the bar exam, to determine the fitness of the examinee if he, faced with varied issues on law, would draw from his training and knowledge, establish concepts and principles of law, as well as applicable jurisprudence, to craft a logical and reasonable resolution to the justiciable issue. So there, aside from being responsive, you have shown to the examiner that you have the analytic skill and insightful mind to present a logical and reasonable resolution to a justiciable issue, hallmarks of a soon-to-be great lawyer. Is this all? Hardly we come to the most important part. Remember, I first told you to understand the problem or issue being raised. Well, it is also important that you make yourself be understood when you answer. Try not to be preachy, don't pontificate. The examiner is not looking for a sermon. What he is looking for is your ability to answer. Thus, you need to be understood. Be direct but not careless. Be confident but never be arrogant in your answers. To be on the safe side, imagine that you are addressing the court. This attitude would make you mindful of how you frame your answers. Our last word of advice. While you may be intellectually ready to take the 4 Sunday exams, make sure your body is ready as well. A well-rested body makes a good host for an academically prepared mind. Keep a positive attitude. Also doesn't hurt if you pray. If you pray. As the annual bar examination serves as the rite of passage that would determine your worthiness to join the ranks of members of the bar and bench, study smart, live clean, and hope for the best. Good luck and God bless in your chosen profession. Keep the faith. Dedication prayer. This work is dedicated to all bar examinees who will take the Philippine bar examinations. Prayer. With all humility, I bow before your divine presence as I undertake this rite of passage, ever charmed by the heavens, anointed by faith, forged by unyielding discipline and fashioned by determination. I beseech you to keep me steadfast in my lawful quest. Give me the strength, the perseverance, the enlightenment to understand your wisdom and your glorious love, that in every answer I give is an answer worthy of your divine grace. As I take the bar exams, I do so with total surrender to your divine will. Guide my mind, my heart, and my hand, that I may prove myself worthy to be called a lawyer of the land. Imbue in me the will and the spirit, that I may constantly strive that in all things you may be glorified. First Sunday bar examinations. So today, put this on record that today I decided to go back to law school. I was absent for 1 sem, so my second sem was for LOA, meaning leave of absence. So nakulingkod ng karuyag, makapalig sa law school, and then they advised me to reread all my books. So now I'm reading. I started with Verba Juris again. Tinry kong ibenta tong mga books na to, but walang nangyari. So hopefully God will help me. Sana maging abogado ako. All bar candidates should be guided that, except when provided in the syllabus, only laws, rules, issuances with their respective amendments and canonical doctrines pertinent to these topics as of June 30, 2019 are examinable materials within the coverage of the 2020 bar examinations. So let's go now to Political and International Law. Political and International Law syllabi, guide, review, list of relevant laws, and issuances for political law. Political international law. If there could be a proper time for mere catch arguments, that time surely is not now. In times like the present, men should uttering nothing for which they would not willingly be responsive through time and in eternity. Lincoln. If there could be a proper time for mere catch arguments, that time surely is not now. In times like the present, men should utter nothing for which they would not willingly be responsible through time and in eternity. The 1987 Constitution. For an in-depth discussion of the Philippine Constitution, please refer to author's book, Philippine Constitution, published by Central Books. The 1987 Constitution, nature and concept of a constitution. The Constitution is the basic law to which all laws must conform. No act that conflicts with the Constitution can be valid. Natural law is thus to be understood not as a residual source of constitutional rights, but instead as the reasoning that implied the necessity to sacrifice natural liberty to government in a written constitution. Natural law and natural rights were concepts that explained and justified written constitutions. So let's repeat. The 1987 Constitution, the fundamental law of the land to which all other laws must conform. It is a written instrument by which the fundamental powers of the government are established, limited and defined, and by which those powers are distributed among several departments for their safe and useful exercise for the benefit of the body politic. It may be that the approach followed may for some be indicative of lack of full awareness of today's stern realities. It is my submission that to so view the transcendental issues before us is to adhere as closely as possible to the ideal envisioned in ex parte Milligan. The Constitution is a law for rulers and for the people, equally in war and peace, and covers with the shield of its protection all classes of men at all times and under all circumstances. It is ever timely to reiterate that at the core of nationalism is a robust concern for individual rights. It is not to deny that the judicial process does not take place in a social void. The questions that with full appreciation of the environmental facts, whether viewed in its temporal or over other relevant aspects, they have to reconcile time-tested principles to contemporary problems. Parts of a constitution. The constitution defines and limits the powers entrusted by the sovereign people to their governments. First, it declares the boundaries where the powers of government cannot go further because individual rights would be impaired. Second, it divides the powers given to the entire government among the various departments and constitutional bodies. Its provisions are therefore both a grant and a limitation of power. Amendments and revisions. Such beliefs, however, should not be equated with a desire to perpetuate a particular official or group of officials in power. Far from it. Such perpetuation is anathema to democracy. My firm conviction that there is an adequate law implementing the constitutional right of initiative does not ipso facto result in the victory of the firma, petition, or of any proposed constitutional change. There are, after all, sufficient safeguards to guarantee the proper use of such constitutional rights and to forestall its misuse and abuse. First, initiative cannot be used to revise the Constitution, only to amend it. Second, the petitioner's signatures must be validated against all existing list of voters and or voters' identification cards. Third, initiative is of reverse power of and by the people, not of incumbent officials and their machinators. Fourth, and most important of all, the signatures must be verified as real and genuine, not concocted, fictitious, or fabricated. The only legal way to do this is to enable the Commission of Elections to conduct a nationwide verification process as mandated by the Constitution and the law. Such verification, it bears stressing, is subject to review by this court. Methods of interpreting the Constitution. Although there are authorities to the contrary, it is generally held that in construing constitutional provisions which are ambiguous or of doubtful meaning, the courts may consider the debates in the Constitutional Convention as throwing light on the intent of the framers of the Constitution. It is true that the intent of the Convention is not controlling by itself, but as its proceeding was preliminary to the adoption by the people of the Constitution, the understanding of the Convention as to what was meant by the terms of the constitutional provision, which was the subject of the deliberation, goes a long way toward explaining the understanding of the people when they ratified it. Basic concepts. Declaration of principles in state policies. It is a policy of the state to promote a high standard of ethics in public service. Public officials and employees shall at all times be accountable to the people and shall discharge their duties with utmost responsibility, integrity, competence, and loyalty, act with patriotism and justice, lead modest lives, and uphold public interest over personal interest. The following state policies shall be observed at all times. The state shall protect the best interests of the child through measures that will ensure the observance of international standards of child protection especially those to which the Philippines is a party. Proceedings before any authority that shall be conducted in the best interest of the child and in a manner which shall allows the child to participate and express himself or herself freely. The participation of children in the program and protection of children's rights to immediate registration and nationality after birth against race statelessness and against discrimination based on their birth status. True to the constitutional policy that the state shall protect and advance the right of the people to a balanced and healthful ecology in accord with the rhythm and harmony of nature. Congress enacted the National Integrated Protected Areas System Act of 1992, NIPAS Act, to secure the perpetual existence of all native plants and animals through the establishment of a comprehensive system of integrated protected areas. The essence of republicanism is representation and innovation. The selection by citizenry of a corps of public functionaries who derive their mandate from the people and act on their behalf, serving for a limited period only, after which they are replaced or retained at the option of their principal. Sovereignty. The right of a government to maintain its existence is the most pervasive aspect of sovereignty, to protect the nation's continued existence from external as well as internal threats. The government is invested with all those inherent and implied powers which at the time of adopting the Constitution were generally considered to belong to every government, such and as being essential to the exercise of its functions. State immunity. The fundamental law of the land provides that the state cannot be sued without its consent. It is a fundamental postulate of constitutionalism flowing from the juristic concept of sovereignty that the state as well as its government is immune from suit unless it gives its consent. The rule in any case is not absolute, for it does not say that the state may not be sued under any circumstances. The doctrine only conveys that the state may not be sued without its consent. Its clear import then is that the state may at times be sued. Suits filed against government agencies may either be against incorporated or unincorporated agencies. In case of incorporated agencies, its suability depends upon whether its own organic act specifically provides that it can sue and be sued in court. Let's have a break. So we are now in state immunity, page 6. The fundamental law of the land provides that the state cannot be sued without its consent. It is a fundamental postulate of constitutionalism, flowing from the juristic concept of sovereignty, that the state as well as its government is immune from suit unless it gives its consent. The rule in any case is not absolute, for it does not say that the state may not be sued under any circumstances. The doctrine only conveys that the state may not be sued without its consent. Its clear import then is that the state may at times be sued. Suits filed against government agencies may either be against incorporated or unincorporated agencies. In case of incorporated agencies, its suability depends upon whether it's an organic act specifically provides that it can be sued and be sued in court. A sitting head of the state enjoys immunity from suit during his actual tenure. The state may not be sued without its consent. It became necessary to distinguish between the state's sovereign and governmental acts, or acts Juris imperii, or its private acts Juris Juris. Presently, state immunity is restrictively extends only to acts Juris imperii or governmental acts, sovereign or governmental acts, while acts Juris gestionis are considered as a waiver of immunity. This traditional rule of state immunity, which exempts a state from being sued into courts of another state without the former's consent or waiver, has evolved into a restrictive doctrine which distinguishes sovereignty and governmental acts. Acts Juris imperii from private, commercial, and proprietary acts Juris gestionis. The suability of government officials depends on whether the official concerned was acting within his official or jurisdictional capacity, and whether the acts done in the performance of official functions will result in a charge or financial liability against the government. Separation of powers. The separation of powers doctrine is the backbone of our tripartite system of government. It is implicit in the manner that the Constitution lays out in separate and distinct articles the powers and prerogatives of each co-equal branches of government. The Belgica versus Ochoa Jr. This court had the opportunity to restate the principle of separation of powers. Refers to the constitutional demarcation of the three fundamental powers of government. The celebrated words of Justice Laurel in Angara versus Electoral Commission, it means that the Constitution has blocked out with deft strokes and in bold lines allotment of power to the executive, the legislative, and the judicial departments of the government. To the legislative branch of government, through Congress, belongs the power to make laws. To the executive branch of government, through the President, belongs the power to enforce laws. And to the judicial branch of government, through the court, belongs the power to interpret laws. Because the three great powers have been, by constitutional design, ordained in this respect, each department of the government has exclusive cognizance of matters within its jurisdiction and is supreme within its own sphere. Thus, the legislature has no authority to execute or construe the law. The executive has no authority to make or construe the law, and the judiciary has no power to make or execute the law. The principle of separation of powers and its concepts of autonomy and independence stem from the notion that the powers of government must be divided to avoid concentration of these powers in any one branch. The division, this hope, would avoid any single branch from lording its power over the other branches of or its citizenry. To achieve this purpose, the divided power must be wielded by co-equal branches of government that are equally capable of independent action in exercising their respective mandates. Lack of independence will result in the inability of one branch of government to check the arbitrary or self-interest assertions of another or others. It is a general policy of the court to sustain the decision of administrative authorities, especially one that was constitutionally created like herein respondent COA, not only on the basis of their doctrine of separation of powers, but also of their assumed expertise in the laws they are entrusted to enforce. It is in fact an oft-repeated rule that findings of administrative agencies are accorded not only respect but also finality when the decision and order are not tainted with unfairness or arbitrariness. It would amount to grave abuse of discretion. To be sure, courts here and abroad have tried to lift the shroud on political question, but its exact latitude still splits the best of legal minds. Developed by the courts in the 20th century, the political question doctrine, which rests on the principle of separation of powers and on prudential considerations, continue to be refined in the means of constitutional law. And the United States, the most authoritative guidelines to determine whether a question is political were spelled out by Mr. Justice Brennan in the 1962 case of Baker versus Carr. Baker versus Carr. Prominent on the surface of any case held to involve a political question is found a textually demonstrable constitutional commitment of the issue to a coordinate political department or a lack of judicially discoverable and manageable standards for resolving it, or the impossibility of deciding without an initial policy determination of a kind clearly for non-judicial discretions, or the impossibility of a court's undertaking independent resolution without expressing lack of the respect due coordinate branches of government, or an initial or an unusual need for unquestioning adherence to a political decision already made, or the potentiality of embarrassment for multifarious pronouncements by various departments on question, unless one of these formulations is inextricable from the case at bar. There should be no dismissal for non-justiciability on the ground of a political question's presence, the doctrine of which we treat is one of political questions, not of political cases. The principle of separation of powers between the executive, legislative, and judicial branches of government ordains that each of these three great branches of government has exclusive cognizance of and supreme in matters falling within its own constitutionally allocated sphere. The principle of separation of powers is implied in the division of powers in the Constitution among the three government branches, the executive, the legislative, and the judiciary. The principle of separation of powers refers to the constitutional demarcation of the three fundamental powers of government. Through Congress belongs the power to make laws, to the executive branch of government through the President belongs to the power to enforce laws, and to the judicial branch of government through the court belongs the power to interpret laws. The separation of powers is a fundamental principle in our system of government, which obtains not through express provision but by actual division in our Constitution. Checks and balances. The Philippine government operates under the complementary principles of separation of powers and checks and balances. A prime example of a constitutional check and balance would be the President's power to veto an item written into an appropriation, revenue, or tariff bill submitted to him by Congress for approval through a process known as bill presentment. The justification for the President's item veto power rests on a variety of policy goals, such as to prevent log-rolling legislation, impose fiscal restrictions on the legislature, as well as to fortify the executive branch's role in the budgetary process. It is meant to increase the chances in favor of the community against the passing of bad laws through haste, inadvertence, or design. The principle of checks and balances is not a general theme for total insulation and interrelation. It is clear that no one office of government works in absolute autonomy. It allows constitutionally enshrined bodies or organs and governmental departments to correct mistakes and prevent excesses done by other branches. Delegation of powers. It is well settled that the power to fill in the details and the manner as to the enforcement and administration of a law may be delegated to various specialized administrative agencies, like the Secretary of Finance in this case. In order to determine whether there is undue delegation or legislative power, the Supreme Court has adopted two tests, the completeness test and the sufficient standard test. There are two accepted tests to determine whether or not there is a valid delegation of legislative power. This, the completeness tests and the sufficient standard test. Both tests are intended to prevent a total transference of legislative authority to the delegate, who is not allowed to step into the shoes of the legislature and exercise a power essentially legislative. Fundamental powers of the state. Police power. The above statement from Linton, however, should be understood in the sense that liberty in the interest of public health, public order, or safety, of general welfare, in other words, through the proper exercise of the police power may be regulated. The individual thought, as Justice Cardozo pointed out, has still left the domain of free activity that cannot be touched by government or law at all, whether the command is especially against or generally against him and others. Proper security measures can always be taken. It is only when petitioners in the exercise of their religious beliefs exceed those bounds and translate their freedom into acts detrimental or inimical to the superior rights of public peace and order, that the test of clear and present danger of substantive evil is met and the acts having a religious significance may be infringed upon in the exercise of the police power of the state. A labor contract merely creates an action in personam and does not create any real right which should be respected by third parties. This conclusion draws its force from the right of an employer to select his employees and to decide when to engage them as protected under our Constitution, and the same can only be restricted by law through the exercise of the police power. Contracts affecting public interest contain an implied reservation of the process of the police power as a postulate of the existing legal order. This power can be activated at any time to change the provisions of the contract or even abrogate it entirely for the promotion or protection of the general welfare. Such an act will not militate against the impairment clause, which is subject to and limited by the paramount police power. Under the fundamental powers of the state, we also have eminent domain. Expropriation is an exercise of the government's power of eminent domain as an inherent attribute of the government. This power is fundamentally limitless, if not restrained by the Bill of Rights without the limitations thus imposed. The exercise of the power of eminent domain can become repressive. Thus, the Bill of Rights should always be a measure and guarantee of protecting certain areas of a person's life, liberty, and property against the government's abuse of power. It has been repeatedly emphasized that the determination of just compensation in eminent domain cases is a judicial function, and that any evaluation for just compensation laid down in the statutes may serve only as a guiding principle or one of the factors in determining just compensation, but it may not substitute the court's own judgment as to what amount should be awarded and how to arrive at such amount. In general, eminent domain is defined as a power of the nation or some great state to take or to authorize the taking of private property for public use without the owner's consent, conditioned upon payment of just compensation. It is acknowledged as an inherent political right founded on a common necessity and interest of appropriating the property of individual members of the community to the great necessities of the whole community. The exercise of the power of eminent domain is constrained by two constitutional provisions: that private property shall not be taken for public use without just compensation, under Article 3, Bill of Rights, Section 9 and 2, that no person shall be deprived of his or her life, liberty, or property without due process of law, under Article 3, Section 1. There is a failure to establish that there is genuine necessity when the basis for passing the ordinance authorizing the expropriation indicates that the intended beneficiary is a private non-profit organization and not residents of the locality. The purpose therefore is clearly non-public. Now, under the powers of the government or fundamental powers of the state, we also have taxation. Now, in taxation, the provisions of the 1997 NIRC cannot be given retrospective to the prejudice of PNB. This is because tax laws are prospective. Tax laws are prospective in application unless the retroactive application is expressly provided. Commissioner of Internal Revenue versus PNB, Philippine National Bank. Taxes cannot be subject to compensation for the simple reason that the government and the taxpayer are not creditors and debtors of each other. Debts are due to the government in its corporate capacity, while taxes are due to the government in its sovereign capacity. Now, national territory, 1987 Constitution defines the national territory to exclude to include not only islands or rocks above water at high tide, but also the seabed, subsoil, and other submarine areas over which the Philippines has sovereignty or jurisdiction. Article 1 of the 1987 Constitution provides the national territory comprises the Philippine archipelago with all the islands and waters embraced therein, and all other territories over which the Philippines has sovereignty or jurisdiction, consisting of its terrestrial, fluvial, and aerial domains, including its territorial sea, the seabed, the subsoil, the insular shelves, and other submarine areas, waters around, between, and connecting the islands of the Philippine archipelago, regardless of their breadth and dimensions, form part of the internal waters of the Philippines. Thus, the Philippine national territory refers to the areas over which the Philippines has sovereignty or jurisdiction. The Constitution mandates the state shall protect the nation's marine wealth and its archipelagic waters, territorial sea, and exclusive economic zone, and reserve its use and enjoyment exclusively to Filipino citizens. Under international law, and in particular under the UNCLOS, the Philippines has jurisdiction over its EEZ and ECS. Thus, under domestic law, the Philippines EEZ and ECS form part of the Philippine national territory, since the Constitution defines national territory to include areas over which the Philippines has sovereignty or jurisdiction, a term which means less than sovereignty. However, under international law, the Philippine national territory refers to the areas over which the Philippines has sovereignty, referring to the Philippines land territory, archipelagic waters, and territorial sea, excluding areas over which the Philippines exercises only jurisdiction, like its EEZ and ECS. China has already invaded repeatedly Philippine national territory in two separate areas, one in the Kalayaan Island group in the Spratlys, and the other in Scarborough Shoal. When China seized in 1988 Subi Reef, a submerged area within the Philippines EECS and beyond the territorial sea of any high tide feature, China invaded Philippine national territory as defined in the Constitution. When China seized 1995 Mischief Reef, a submerged area within the Philippines EEZ and beyond the territorial sea of the any high tide feature, China invaded Philippine national territory as defined in the Constitution. When China seized in 2012 Scarborough Shoal, a rock above water of high tide and constituting land territory under international law, China invaded Philippine national territory as defined in the Constitution and as understood in international law. Public Act No. 9522, amending the Philippine Baselines Laws, expressly declares that Scarborough Shoal is part of Philippine territory over which the Philippines exercises sovereignty and jurisdiction. So, I guess I have to stop. No. I'll continue. It's over break. Citizenship. Kinds of citizenship. Purpose of distinguishing citizenship and kinds of citizenship. Solicitor General makes the further point that the framers worked to create a just and humane society, that they were reasonable patriots, and that it would be unfair to impute upon them a discriminatory intent against foundlings. He exhorts that, given the grave implications of the argument that foundlings are not naturally born Filipinos, the court must search the records of the 1935, 1973, and 1987 constitutions for an express intention to deny foundlings the status of Filipinos. The burden is on those who wish to use the Constitution to discriminate against foundlings, to show that the Constitution really intended to take the spot, the dark side, and inflict this across-the-board marginalization. We find no such intent or language permitting discrimination against foundlings. On the contrary, all three constitutions guarantee the basic right to equal protection of the laws. All exhort to state to render social justice of special consideration are several provisions in the present charter. Article 2, Section 11, which provides that the state values the dignity of every human person and guarantees full respect for human rights. Article 13, Section 1, which mandates Congress to give highest priority to the enactment of measures that protect and enhance the right of all the people to human dignity. reduce social, economic, and political inequalities. Article 14, Section 3, which requires the state to defend the right of children to assistance, including proper care and nutrition, special protection from all forms of neglect, abuse, cruelty, exploitation, and other issues prejudicial to their development. Certainly, these provisions contradict an intent to discriminate against foundlings on account of their unfortunate status. Other circumstantial evidence of the nationality of petitioner's parents are the fact that she was abandoned as an infant in a Roman Catholic church in Iloilo City. Paul Yamanes versus Commission on Elections. She also has typical Filipino features: height, flat nasal bridge, straight black hair, almond-shaped eyes, and an oval face. There's a disputable presumption that things have happened according to the ordinary course of natural and ordinary habits of life. All of the foregoing evidence that a person with typical Filipino features is abandoned Catholic Church in a municipality where the population of Philippines is overwhelmingly Filipinos, such that there would be more than 99% chance that a child born in the province will be a Filipino would indicate more than ample probability, if not statistical certainty, that petitioner's parents are Filipinos. That probability and the evidence on which it is based are admissible under Rule 128, Section 4 of the Revised Rules of Evidence. As a matter of law, foundlings are as a class natural-born citizens. Now the 1935 Constitution's enumeration is silent as to foundlings. There is no restrictive language which would definitely exclude the foundlings either because of silence and ambiguity in the enumeration. With respect to foundlings, there is a need to examine the intent of the framers in Nitafan versus Commission of Internal Revenue. This court held that the entertainment of that intent is but in keeping with the fundamental principle of constitutional construction, that the intent of the framers of the organic law and of the people adopting it should be given effect. Primary task in constitutional construction is to ascertain and thereafter assure the realization of the purpose of the framers and the people in the adoption of the Constitution. It may also be safely assumed that the people in ratifying the Constitution were guided mainly by the explanation offered by the Africans, who are citizens. No less that canon is a Constitution enumerates who are Filipino citizens. Among those listed are citizens by naturalization. Naturalization refers to the legal act of abducting an alien and clothing him with the privilege of a native-born citizen. Under the present laws, the process of naturalization can be judicial or administrative. Judicially, the naturalization law provides that after hearing the petition for citizenship and the receipt of evidence showing that the petitioner has all the qualifications and none of the disqualifications required by law, the court may order the issuance of the proper naturalization certificate and its registration in the proper civil registry. On the other hand, Republic Act No. 9139 provides that aliens born and residing in the Philippines may be granted Philippine citizenship by administrative proceeding by filing a petition for citizenship with a special committee, which in view of the facts before it may approve the petition and issue a certificate of naturalization. In both cases, the petitioner shall take an oath of allegiance to the Philippines as a sovereign nation. At the outset, it must be noted that presumptions regarding paternity is neither unknown nor unaccepted in Philippine law. The Family Code of the Philippines has a whole chapter on paternity and filiation. That said, there is more than chapter on paternity and filiation. That said, there is more than sufficient evidence that the petitioner has Filipino parents and is therefore a natural-born Filipino parenthetically. The burden of proof was on a private respondent shows that petitioner is not a Filipino citizen. The private respondent should have known that both of petitioner's parents were aliens. Her admission that she is a foundling did not shift the burden to her because such status did not exclude the possibility that her parents were Filipinos. specialized in the case where there is a high probability, if not certainty, that parents are Filipinos. Who can be citizens. Citizens is a legal device denoting political affiliation. It is the right to have rights. It is one's personal and permanent membership in a political community. The core of citizenship is the capacity to enjoy political rights. That is the right to hold public office, the right to participate in government principally through the right to vote, the right to hold public office, and the right to petition the government for redress of grievances. Citizenship also entails obligations to the political community of which one is part. Citizenship, therefore, is intimately tied with the notion that loyalty is owed to the state, considering the benefits and protection provided by it. This is particularly so if these benefits and protection have been enjoyed from the moment of the citizen's birth. Citizenship is a personal, more or less permanent membership in a political community. It denotes possession within the particular political community of full civil and political rights, subject to special disqualifications such as minority. Citizenship is a personal, more or less permanent membership in a political community. It denotes possession within that particular political community of full civil and political rights, subject to special disqualification. No less than the 1985 Constitution enumerates who are the Filipino citizens. Among those listed are citizens of naturalization, which refers to the legal act of adopting an alien and clothing him with privilege of a native-born citizen. Number 4, Section 2, CA 473 provides as qualification to become a Philippine citizen. You must own real estate in the Philippines worth not less than 5,000 pesos, Philippine currency, or must have no lucrative trade, profession, or lawful occupation. Modes of acquiring citizenship. Under existing laws, an alien may acquire Philippine citizenship through either judicial naturalization under CA 473 or administrative naturalization under Public Act Number 9139, Administrative Natural Law of 2000. A third option called derivative naturalization, which is available to alien women married to Filipino husband, is found under Section 15 of CA 473. Domestic laws on adoption also support the principle that foundlings are Filipinos. These laws do not provide that adoption confers citizenship upon the adoptee. Rather, the adoptee must be a Filipino in the first place to be adopted. The most basic of such laws is Article 15 of the Civil Code, which provides that laws relating to family rights and duties, status, conditions, legal capacity of persons are binding on citizens even though living abroad. Philippines, even though living abroad, adoption deals with status, and a Philippine adoption court will have jurisdiction only if the adoptee is a Filipino. Recent legislation is more direct. Public Act Number 8043, entitled an Act establishing the rules to govern the inter-country adoption of Filipino children and for other purposes. Republic Act Number 8552, entitled an Act establishing the rules and policies on the adoption of Filipino children and for other purposes, otherwise known as the Domestic Adoption Act of 1998, and this court's IM number 02-6-02-SC, or the rule on adoption, all expressly refer to Filipino children and include foundlings as among Filipino children who may be adopted. It has been argued that the process to determine that the child is a foundling, leading to the issuance of a foundling certificate under these laws, and the issuance of such certificate are acts to acquire perfect Philippine citizenship, which make the foundling a naturalized Filipino at best. This is erroneous under Article 4, Section 2. Natural born citizens are those who are citizens of the Philippines from birth without having to perform any act to acquire or perfect the Philippine citizenship. In the first place, having to perform an act, which means that the act must be personally done by the citizens. In this instance, the determination of foundling status is done not by the child but by the authorities. Secondly, the object of the process is the determination of the whereabouts of the parents, not the citizenship of the child. Lastly, the process is certainly not analogous to naturalization proceedings to acquire Philippine citizenship or the election of such citizenship by one born of an alien father and a Filipino mother under the 1935 Constitution, which is an act to perfect it. In this instance, such issue is moot because there is no dispute that petitioner is I-founded, as evidenced by a founding certificate issued in her favor. The decree of adoption issued on May 13, 1974, which approved petitioner's adoption by Jesusa Sonora Poe and Ronald Alan Kelly Poe, expressly refers to Emiliano and his wife Rosario Militar as her founding parents, hence effectively affirming petitioner's status as a foundling. Jurisprudence dictates that in judicial naturalization, the application must show substantial and formal compliance with the law. In other words, an applicant must comply with the jurisdictional requirements, establish his or her possession of the qualifications and none of the disqualifications enumerated under the law, and present at least 2 character witnesses to support his allegations. Section 2 of the Naturalization Law clearly sets forth the qualifications and that must be possessed by any applicant. An applicant for naturalization must comply with the jurisdictional requirements, established his or her possession of the qualifications and none of the disqualifications enumerated under the law, and present at least 2 characters witnesses to support his allegations. Modes of losing and acquiring citizenship. Republic Act No. 9225 is a repatriation statute and has been described as such in several cases. They include Sobehana Condon versus Comelec, where we described it as an abbreviated repatriation process that restores one's Filipino citizenship. Also included is Pareño versus Commission on Audit, which cited Tabasa versus Comelec, where we said that the repatriation of the former Filipino will allow him to recover his natural-born citizenship. Pareño versus Commission on Audit is categorical that if petitioner requires his Filipino citizenship, he will recover his natural-born citizenship. Philippine citizenship may be lost or reacquired in a manner provided by law. Commonwealth Act No. 63, which was in effect when private respondent was naturalized an American citizen on October 18, 2001, provided in Section 1, Paragraph 1 that a Filipino citizen may lose his citizenship by naturalization in a foreign country. Thus, private respondent lost her Philippine citizenship when she was naturalized an American citizenship. However, on July 7, 2006, she took an oath of allegiance to the Republic of the Philippines under Section 3 of Republic Number 9225. There, 3 days later, July 10, 2006, she filed before the Bureau of Immigration and Deportation a petition for reacquisition of her Philippine citizenship. Shortly after, this petition was granted. Republic Act No. 9225 superseded Commonwealth Act No. 63 and the Republic Act No. 9171, specifically to do away with the provisions in Commonwealth Act No. 63, which takes away Philippine citizenship from natural-born Filipinos who become naturalized citizens of other countries. Dual citizenship and dual allegiance. In the case of those who became foreign citizens of the Republic Act No. 9225 took effect, they shall retain Philippine citizenship despite having acquired foreign citizenship, provided they took the oath of allegiance under the new law. Dual citizenship arises when, as a result of the concurrent application of the different laws of 2 or more states, a person is simultaneously considered a national by the said states. For instance, such a situation may arise when a person whose parents are citizens of a state. Dual allegiance refers to the situation in which a person simultaneously owes, by some positive act, loyalty to 2 or more states. While dual citizenship is involuntary, dual allegiance is the result of an individual's volition. So that ends the chapter on citizenship. Ito yung pinakamalugo, which is legislative power. And let's have a break.